viewers, welcome to another edition of Legal Hour. My name is MC Chaka. I'm your host for this insightful and educative program that we bring to you every Tuesday and Thursdays. Tonight, I'll be here with my one and only lawyer. He's been our guest for a long time. Tonight, he's going to be with us, and we've got a very exciting and interesting topic to discuss. We're going to talk about immigration matters. We're going to talk about EU settlement scheme and updates and late applications. We all know that after the Brexit, end of June to this year, people have been confused. People don't know whether they can still make any application under the EU settlement scheme. So this has been very frustrating to a lot of people. We know a lot of people have made applications that has also been refused. So tonight, lawyer is going to talk about how or whether we have any grounds to make application under the EU settlement scheme. So please make sure you invite your friends, you invite your family, everyone that you think will benefit from this program. We're going to start very soon. I'll be introducing lawyer very soon. So please make sure you share the link as well. As soon as you receive it, make sure you share for someone else to benefit from this program. In addition, this program, whilst on Facebook, you can also get it on our radio channel, that is City Media Radio. If you go to Modern Ghana, it's part of the abroad radio. City Media Radio is there, and then also YouTube. This program is there. Solicitor Thomas Beyebenwo, you get this program. So thank you very much, and I hope you're going to share for someone to benefit. I'll be back briefly, and then I'll introduce lawyer for the program to start. We've got very good topics and very good questions to ask. So please make sure that you share. And later on, I'll give viewers the opportunity to call the studio line to ask questions as well. So I'll be right back. Please don't go away. Stay tuned. viewers, welcome back. So I've got lawyer in the studio, and as I said earlier, we're going to talk about EU settlement scheme updates that obviously has been received, and then whether late applications are still possible. So I'll first of all welcome lawyer, as I always do, lawyer Thomas Beyebenwo. Welcome to the show.
Thank you, MC Chaka.
Good. It's a pleasure to have you all the time in the studio to educate and impart your knowledge on us, especially people from the African communities. Thank you very much for your good services. Thank you.
Thank you. And I'm also full of praise for those who are always here to watch us and to listen to the update that we always bring to them both on Tuesday and Thursday. So today is another opportunity for us to discuss a distinct topic, which is quite topical in terms of what is happening around us.
Okay, so lawyer, before I go on with the topic for tonight, just want you to sell yourself a bit. I've been selling you a lot, but tonight it might be the first time somebody watching you. So please let viewers know who you are, your firm, and where you guys are located, please. Thank you.
Thank you, MC Chaka, and good evening, everyone who is watching us now or who may watch us later after we have left the studio, because the Facebook and the YouTube stuff will still remain there. You can always watch and educate yourself with it or share with friends and family. If today is the first time you are watching us, as MC said, we do this program in English on Tuesdays, and then we do it also in Chi on Thursdays, 8:30. My name is Thomas Beyebenwo. I'm a partner for City Law Solicitors. City Law Solicitors, I'm sure that those of you who have been our clients, we try our best to get the ultimate outcome for clients. And this is not to brag, but our success rate for clients who can testify on this platform is very high. We specialize in numerous areas of law. We specialize in employment law. If you ever had any employment matter in terms of dismissal, unfair dismissal, discrimination, if you are being made redundant and you need a solicitor to sign your settlement agreement, we can support you in these areas. Those of you who are also employers that require a solicitor or a lawyer to assist you with drafting employment contracts, dealing with employees who have various issues or causing various issues for you, we can also support in those areas. Civil litigation and commercial dispute, we also specialize in that area. We can assist you in terms of whether you have commercial or you have transactions, being a company, or if you're a company and you need a lawyer to assist you in shareholders agreement, partnership agreement, all sorts of stuff in relation to commercial law, including if someone owes you and then you need a lawyer to assist you, we can also help. We also specialize in clinical negligence and personal injury. If you ever had an accident that was never your fault, for example, you work for a factory, you had an injury whilst at work, or you had an injury in a car, we are always there to assist people who have sustained injuries that are not their fault. If you went to the NHS for treatment and you ever had some issues with treatment, critical negligence, we can also assist you. Immigration, which is what we are doing now, family law, matrimonial law in terms of divorce and child arrangement order, and all sorts of areas under the family law, we can assist. So this is city law for you. Don't look far. If you have any legal area, a problem in any of these areas, you can always count on us.
Thank you very much, lawyer. You've really done well for selling yourself. City law, if you need anyone to represent you in all aspects of law or legal matters, don't look no far. Make sure you contact them, and then they'll be there to support you. So viewers, if you've just joined us, we're talking about EU settlements, the updates that have been received, and then of course whether late applications could be possible. So lawyer, quick question. The EU settlement scheme, is it still open for people to make applications?
Yes, it is. As you know, or most of you are familiar, when UK left the European Union, I think in January 2020, we went into transitional period from January 2020 to December 2020. So we're in that transitional period for people to make application to regularize their stay, both EU nationals and family members. And then the deadline, when we finally left in December, the deadline was extended to June 2021. And then there was a lot of complaints that people have said not be able to regularize their stay, both EU citizens and their third country family members. And therefore, from June 2021, it was also further extended for what we call late applications. So the scheme is still operating both abroad and in country.
Okay, interesting. So people that were not able to submit their application before end of June this year, they still have a chance to submit the application.
Exactly.
Okay. So talking about the scheme, which category of people are eligible, entitled to make application under the scheme?
Yes. You realize that when we left the European Union in December 2020, there was what we call withdrawal agreement. Now that withdrawal agreement, UK set out the people that can make applications from December 2020 in that agreement. So within that, it is family members, for example, children under 21 or above 21 with some financial dependency, parents and grandparents, and spouses. Those are the categories of people that are permitted or eligible to make applications under the scheme.
Okay, thank you very much for that. So people who make application under the scheme, do they have to give any explanation as to why they are late? Because we all know it was for June. So is there any sort of application needs to be given to the Home Office for late applications?
Yes, the people can give all kinds. There are numerous reasons people can give, and amongst them could be they have problem with internet or illiteracy. They were not aware, and numerous other reasons as well. And quite frankly, there are several people who have permanent residence card and residence cards who think that they have indefinite leave to remain, so they are not obliged, or it's not mandatory for them to make those applications. And we have of recently receiving some of our clients that we dealt with their case many years ago, turning up not being aware that they are meant to do the settlement scheme. So this announcement is quite important. Those people now have a second opportunity to make these applications, and merely by saying that they were not aware that they were required to do it will suffice for them to do it. We shouldn't lose sight of the fact that we had a Windrush scandal in this country when most of our fellow Caribbeans refused to regularize their stay, and eventually most of them were removed or deported whenever they were involved in certain criminal activities, or for whatever reason they were apprehended by the immigration officers. So it is important that people take this last minute opportunity to regularize their stays under the scheme.
All right. Thank you, lawyer. I understand. I know that some people are being refused as well for these applications. So is there any particular reason why many people are being refused under the scheme?
Yes, as you know, when the UK left the European Union between January 2020 to December 2020, that was a transitional period for people to make applications under the scheme. And then in December 2020, we left finally, and then there was another extension of time for people to make it up to June 2021. So one of the main reasons that applications are being refused recently is the fact that, if I should use this legal terminology, Home Office has intention to stop the floodgate, which is for people from member states who somehow just come and apply under the scheme. So mainly, even if you're a third country national, by this I mean Ghanaian, Nigerians and all that, if you don't have evidence to show that you were residing here before December 2020, then it's likely that those applications are going to be refused. Of course, there are other tangible reasons that applications are also refused, but perhaps prior to December 2020, it was easy for people to be granted because technically they were in situ or they were in the country. These days they are quite strict in terms of one showing that they have residence. So if you are somebody who is watching me tonight and you don't have that evidence, you must find a way to look for it, to give it to your lawyer, because most of the reasons we are receiving for those refusals are based on those reasons.
Okay, so lawyer, let me stress on this. Are there any mandatory grounds for these refusals? Because I know Home Office have the right to obviously refuse applications, but then you lawyers have the right to challenge Home Office decision as well. So just want to quickly touch on this one, that these refusals, are they binded by any law, or are they mandatory for people to be refused under the scheme?
Yes, thank you for such a laudable question. Now, there are mandatory grounds for refusing applications, and those grounds are set out in the Appendix EU Rule 15, EU 15. It sets out those mandatory grounds. For example, somebody who has an extant deportation order or is subject to deportation order, persistent criminal who has been committing offenses, those who have exclusion order. There are some people, I'm sure that people were aware that somebody, I think from Belgium, he was coming to this country because of certain views that she had at the time that was homophobia. He was excluded. So those people who have exclusion order in place, that is the mandatory grounds for them to be refused. Those who have deportation order, those who have some criminal convictions, serious criminal convictions, it's also mandatory grounds for refusal. And then there are also those who pose risks to public safety and health. This was something that was in the EU regulations, but they have been imposed or being exported into the Rule 15 of Appendix EU. So these are the mandatory grounds. But I must stress here that any other ground that is used to refuse must be appropriate. So you see that there is some kind of flexibility there for them to refuse. And also there is some flexibility for lawyers to also challenge those grounds once they fall outside the mandatory grounds.
Yeah, I was going to come to that, but I mean, you've hit the nail right on the head. Because the fact is that I know there will be a room for you, I mean, as lawyers, to challenge Home Office. Has there been any cases that all the grounds that the mandatory grounds that you've given were probably not the case, but then the person has legitimately or submitted all the documents and evidence that is required for the application, and yet still has been, refused? So in that case, what can you do in your capacity as a lawyer to sort of challenge Home Office decision and make sure that the application is obviously taken into consideration?
Thank you. Yes, this is an area that I've been dealing with on a regular basis, and I deal with a lot of cases regularly. In fact, when you look at some of the reasons for refusal, they are quite inappropriate. And if you look at Appendix EU, Rule EU 14, it sets out some of the conditions that applicants need to satisfy, whether they are EU citizens or their family members. And then, as I mentioned, in terms of proof of residence, whilst applications which are recently being made need to satisfy that requirement that they were in the UK before December 2020. Recently, those grounds are being used to refuse when people are not able to provide certain evidence. And if you look at the guidance, it sets out numerous evidence that people can produce to show that they were in this country. For example, if they had a travel ticket, flight ticket, or visa to this country that was before December 2020, if they even went to the shop and bought something and they were sent an invoice with the address dated with their name on it, if they have a bank statement, utility bills, we have moved from the times when EU family members or EU nationals were required to exercise what they call treaty right in terms of either being a worker, a self-employed, a student with private medical insurance, or being self-sufficient. We've moved from that stage to a stage where it's meant to be very flexible for people to be granted these settlements under the scheme. But rather, caseworkers are being very strict, as I've already mentioned, maybe because of the floodgate. So most of these decisions are going to be challenged in the immigration tribunal, and quite rightly so.
Okay, so I mean, in that case, or if I understood you clearly, that means that that treaty that obviously they had to exercise, being it unemployment or student, or somebody with a medical issue and maybe not eligible to work, anything obviously to warrant or to give them the ability to let their people, their family members benefit from getting a permanent stay or resident in this country, now is changed and is flexible.
Yes.
So
now they only need to show that they are residing in this country by simply proving that they have documents to show that they are living in this country.
So even if they are not working, they are not. That's when people some people have still not gotten the fact that things have changed. Wow.
Things are changing.
Viewers,
they don't have to show that.
This is very interesting because before it was very difficult for EU member states living in the UK to exercise that right. You need to be either in employment, full-time education, as lawyer outlined. But now the good news is that once they are living in the UK and they've got evidence to indicate that they are in the UK, they don't need to prove all this. It's very flexible. So if you are a member of the EU state living in the UK, first of all, it's not too late for you for your people, your family, let's say your husband or anyone, dependents or whatever, to benefit and get their stay or their right to live in the UK. Viewers, if you've just joined, we're discussing the updates in relation to the EU settlement scheme, and then also to talk about late applications. And lawyer has already covered the areas that the scheme is still open, and he's outlined the category of people who are eligible for the applications, and obviously reasons what you need to give to indicate for late applications. Why is it that many people are being refused? He's explored on that, and we understand exactly what people are being refused. So I think there's a lot more that I'm going to ask lawyer, but until then, let me acknowledge my viewers on Facebook. I must emphasize that a lot of people make this program interesting, and that gives us the motivation to come here all the time to obviously do the program. Desmond Beniana, Desmond is saying, good job, lawyer and Chaka. Desmond, watching you live from Wellingborough. Thank you very much, Des. Thank you for watching. Nana Ajele, Nana is saying, good job, sir. Keep it up. Felicia Opoku, good job, lawyer. Okay, Nana Ajele once again saying, I'm one of the clients. All right, thank you, Nana, and thanks for watching as well. Yeah, so Cornelia from Pomajima. Where have you been, Cornelia? I've really mixed you. Anyway, thanks for coming tonight. Cornelia is saying, good evening, Lawyer Thomas, Chaka, and City Law family community members. Let's all share and invite as we've been always doing. Cornelia, you're right. City Law is a community. We're building a community, supportive community that obviously will be there for everyone. In all areas of law, don't look further. City Law is there for you. Ama Ampofo-J is the host for Apomding Jumedio Apomding program in Multimate Radio in Ghana. Ama, thank you very much for watching and thanks for sharing as well. So Kofi Lancaster, V-Mate. Chief. Yes, Chief Lancaster is watching. Thank you very much, Chief. I hope you're doing well, you and your family. Nana Poku Patterson, Ura is watching live from Hackney. Anita Edu, my own sister, Mami Esi. Anita is watching from Northampton. So Anita is saying, Chaka, looking sharp. Thank you, my sister. I'm learning from you. Yvonne Patronis or whatever, cosmetics. Thank you very much, Anita. And Cornelia, wow, very interesting. As said MC Chaka. Yeah, so please make sure you share. It's very interesting. Anytime we're here, we want people to watch us. And then, of course, we've got City Media. So this program is being channeled through the online radio, which is City Media Radio. You can access this from Modern Ghana, the abroad section. You can get City Media Radio. And this program is live on radio. And hey, Samuel Afarijai. Samuel Afari is watching as well. Thank you for watching. Mr. Leboko and his wife Mary watching all the way from Belgium. And of course, Senior Stone, Big Stone and Stonewa also watching or listening all the way from Amsterdam. Thank you very much. You guys mean a lot to us. It's because of you that we bring this program. So keep watching, keep supporting this positive cause. We are building a community that will support everyone. So let's keep sharing and motivate ourselves. Thank you. All right, lawyer. Back to my questions. So, before I ask you this question, I want you to explain extended family members, and then obviously, close family members. Because I'm sure there are two of them, and before we know the close family members could maybe entail children or whatever, and then extended. But please give us the distinction between these two type of members before I ask you the next question.
Yes, normally. Extended family members are what they call dependent relatives. So dependent relatives include nephew, nieces, uncles. It also involve those who are children but far more than 21 years. So they are more or less extended family members by their name. They are not nuclear. They are not in the nuclear lineage. So they could be uncles, aunties, and all these things. But they are also dependent relatives. And obviously, those who are close family members are those who are children, spouses, parents, grandparents, parents of the spouse, and grandparents of the spouse, and children of the spouse under the age of 21.
Okay, so the reason why I asked you to sort of give a brief description or update on that is because now I understand that extended family members can also benefit from this EU family scheme application. I understand you've got an update. So what is the current update in relation to extended family members applying or benefiting from this scheme?
Yes, this is another important area. If everyone is watching us tonight or listening through the radio, and you have a family member who has been involved in some of these problems that has been happening over the time, the good news is that Home Office, because of a lot of complaints from lawyers, civil societies, and all that, they have made concessions. But before I go further to give details of the concession, I want to set the background to this problem. Now, the background to this concession, which Home Office have just made in favor of dependent relatives, is this. Article 10, subsection 3 of the UK-EU Withdrawal Agreement set out that dependent relatives who made application before December 2020 were eligible to be issued what they call family permits. Now, so most dependent relatives made these applications within that, before that December. Remember I set out that January 2020 we went into transitional agreement, and then December 2020 we left the European Union finally. So these dependent relatives were eligible to make applications before this December 2020. When you look at the Article 10 subsection 3 of the UK-EU Withdrawal Agreement. So people made these applications, dependent family members like nieces, nephews, and all those categories of family members made applications before that December 2020. Some of those applications were refused, they were challenged, the appeals were allowed. Some were still pending by the time we entered into January 2021 or the year 2021. And some of those applications were also made under the EA regulations. So by June 2021, Home Office excused for denying these people those family permits, including those whose appeal were allowed, were that because those family permits were not going to be valid for travel, they were not going to issue to them, even though the court or the tribunal have allowed the appeals. Or those who were spouses and made applications under the EA regulations, and some of them were refused and were challenged and their appeals were allowed. They said that because those EA family permits were no longer valid to travel after June 30th, 2021. So all these people were in abeyance, which means that the appeals were allowed, the applications, some of them were granted, but they could not travel. And this was why there were a lot of complaints. And eventually, Home Office has conceded, and they have now made a concession that all those people who were denied right to be granted those family permits under the old law can now be granted under the EA family permit scheme, so that they can also come to the UK, and within 3 months of arriving, they can apply under the scheme and be given this 5-year period. So it's a good news for dependent relatives. But I'm not saying that means that extended family members can now make applications under the scheme.
Okay.
I am saying that those who made those applications before December 2020, for one reason or the other, they were not granted. Recently, I had a family friend who called me from the US and said that he has a sister who was involved in that category. If he's watching tonight, that gate has now been opened. So everybody who knows anybody in that category, I will entreat them to inform them that as a Papa Biabuja.
Okay. So, lawyer, in that case, that is applicable for to those who made the application, prior to the Brexit or the deadline. The
deadline of December 2020.
Okay, so let's get it really clear. So that means they can't make the new application.
No.
Now, but then new applications can be made by close family members.
Family members, that's right.
Okay, that makes sense. All right. So viewers, that is there's some sort of distinction. People that made the application in the past, for some reasons, some of them were refused. I know a lot of people that were refused at that time. Lawyer is saying now Home Office or I mean, they giving consideration for this to be overlooked. So you can challenge it, or you can make another application based on your previous application. So that's a good news.
Yeah, they can they can now contact the centers and then get their visas, because most of them were entitled to do visas, but they were either not issued, because the argument was that even if they issue after June 2021, they could not use it to travel.
Yeah.
Or because extended family members were no longer included after December 2021. But these were people who made applications before that deadline.
Oh, okay.
So this concession is specifically for those categories of people whose application were either refused and their tribunal allowed their appeals, or the Home Office confirmed that they were entitled to the family permit, that were not, but they were not going to issue them because they couldn't use it to travel because of the, so those are the categories of people that this is a good news for them. And their family members, or they can contact the embassies, and then they will be rightly issued those visas.
All right, that's good. That's good news anyway. Lawyer, what about people that married after December 2020? Do they have to go back to their country to make this application, or they can apply whilst they are in the UK?
Yes, this has also become another topical issue. I must point out here that when the transitional period was in period between January to December 2020, any relationship or marriage that was contracted within January or before December 2020, those parties are still eligible to make applications under the scheme as at today until further notice. But obviously that will be what they call late application. So they may have to give reasons why they didn't do the application earlier. And most Ghanaians, because of the fact that they have this customary marriage, that if you look at the Customary Marriage and Divorce Registration Act 1991, which is an amendment from the 1985, it makes registration optional. It means that those people who were married before December can even register their marriage and then rely on it to make applications. But for those who have, for one reason or the other, formed a relationship or contracted a marriage after December 2020, then they may have to make applications under the Appendix FM because their relationship falls outside the transitional period. And the point is that it is not everybody, one of them needs to go to abroad to make those applications. Remember we discussed non-biological parents.
Oh yes, yeah, we did. Yes.
Last week Thursday. Yes, you can either rely on those grounds, or the fact that the spouse have a child in the relationship means that there is a family life under Article 8. Therefore, they can also make the applications here. So it's not everybody that needs to go back and make those applications if their marriages are contracted after December 2020.
All right. So, lawyer, one thing that a lot of people are really scared to do is when maybe they've made an application, especially for marriage, and the Home Office want them to come for an interview. So, what I want to ask is it mandatory for people to be interviewed? I mean, for Home Office to do that before they can issue visas to married couples who wants to use the settlement scheme?
Yes, this is another topical area, and it's quite sensitive. I have been going through the guidance, and whenever I am on this platform and I'm talking, I give the source of my grounds for making any statement. So I speak of facts. Now, the point is that if you look at the guidance which was issued for caseworkers to follow in making decisions, issued on the 20th of July 2021, which is quite recent and still valid. It sets out circumstances where people can be invited to give clarification of their relationship. But what has been noticed or has come to be noticed is that those invitations are now being used purely, because I, for example, was dealing with a case recently where a caseworker was shouting marriage of convenience. It's nowhere in the guidance. The guidance is that if you have if there's any issue that is not clear to the caseworker, is entitled to invite parties to come for an interview. But I must say here that even the guidance says that if a party fails to attend an interview on 2 occasions, because they normally invite people 2 occasions and then they refuse. If parties refuse for whatever reason, or they are unable to attend interview at 2 occasions or invitations, it is not in itself a grounds for caseworkers to refuse those applications.
So what can they do? I mean, that's
so parties can opt out that if one of the parties, maybe remember, in normal relationship, you may have some dispute with your wife or your husband.
Yeah.
And therefore, it's at a point, sometimes you may even have some financial hardship. She might say that, well, I don't think I want to support today. Maybe for one reason or the other.
Exactly.
Quite rightly so.
Correct.
So does that mean that that relationship is not genuine just because one party has refused or is reluctant to accompany another person for an interview? It's not the case. So the guidance makes it clear that.
Yeah, but lawyer, so the other party is depending on the other one, obviously, to make the application.
Yes.
So, and I think Home Office will need consent from the other person, obviously, before it can go through. So if the other party bounces or decide not to be part of it, then obviously there wouldn't be any ground for the application to go ahead.
That's quite a good question. Let me set out the legal framework. I enjoy answering some of these questions. And of course, I am not saying that it's so easy. I have clients that also have issues with them, and I'm even challenging some of those decisions in the tribunal. So I am not saying that all cases are going to be successful. In fact, that's why the tribunal is there. But let me set out the legal framework here. If you look at Appendix EU, Rule 14, EU 14, it sets out the documents or the requirements that one needs to satisfy when those applications are made. One is being related to the person. It could be marriage, which means that you need to show marriage certificate. It could be a father, mother, or child, which means that you need to show relationship by birth certificate. And then the other condition is also residence. I've already said that days when people were meant to exercise duty rights are over. Now people just need to show residence. So these are the 2 conditions that people need to satisfy when applications are made. So the rules do not set out interviews. If you come to the guidance sets out interviews. That's why I quoted the guidance when I was making my submission. But even in the guidance, which is instruction that caseworkers are meant to follow, it says that caseworkers cannot refuse application mainly because someone has failed to attend interview at 2 occasions or 2 invitations. So it means that if one reason or the other, that person has not been able to attend the interview, then caseworkers cannot use that to refuse. But they can refuse if Rule 14 requirements are not satisfied.
Okay, that's
for example, their relationship. Yeah. So it's an opportunity for people to give further information. not grounds for refusal.
Okay, that's fine. Thank you very much for taking your time to explain this. So, in that case, if you've got a partner, and I want to stress more on the argument section, or maybe when there's a dispute and one party is not willing to go with the other, and obviously you've got all the documents and you submit on your own. I mean, in that case, Home Office do not have the right to refuse you based on the fact that your other partner has not accompanied you or consented to that or whatever. They still have to go by the documents you presented to make a decision on the application. Is that correct?
Yes. Let me make a point clear here. Just last week, maybe one of my clients might be watching us. I made application for his child to join him here. In fact, I was so impressed. He brought every document that was required under the rules. I submitted the application. I was very confident that the application was going to be granted, entry grants application. But it was refused. So I challenged the decision in the tribunal. And then we had a hearing, I think last week. The appeal was allowed. Why? Because the requirements have been satisfied. So I'm saying that the fact that one meets the requirements doesn't mean that applications cannot be refused.
Okay, yeah.
Case workers may still refuse applications, either by making some mistake or just because of the fact that they feel that that person does not deserve the visa. But in any case, that is why the tribunal is there. So that when those applications are refused for grounds that are inappropriate, then those parties are entitled to challenge them in the immigration tribunal.
So, lawyer, let's say they've granted an interview to verify certain things, to clear that everything is okay. The applicant, can he or she attend the interview alone? Or
yes, my clients, if some of them are watching, they can bear me out. I have on numerous occasions challenged Home Office on the basis that if one of the parties is unable to attend, whatever information they need from the two parties, they can get from the one party, the other party, mainly the applicant. So, for example, about a week or two ago, one of my clients, he attended the interview alone. And we are waiting this. And in the end, the caseworker could not even give any reason why he invited my client for the interview. He ended up saying that he was not satisfied with the proof of address and he should bring more proof of address. So clearly, these grounds are being misused to refuse applications. And it's not fair. And that's why I am doing this program, for people to be aware of their rights. Because with city law, we are building a community where people will know their rights and will be able to defend themselves when their rights are being trampled upon.
Thank you very much, lawyer. City law is building a community for people to know their right, especially when their rights being trampled upon. Lawyer Beyebenwo Thomas, thank you very much for taking your time to go through this. Before we go for a quick commercial break and open the phone lines, I'm going to ask you this quick question. So, lawyer, if people are making application under the EU settlement scheme, now that Brexit is in place, does it follow the Appendix FM, the UK rules in terms of maybe fee payment and stuff like that, or it's still part of the EU? So obviously there's nothing in relation to that people benefit from the fee waiver that people, the EU citizens were not paying.
Good. This is a quite broad question. Let me take my time. The point is that currently both the EU settlement scheme for in-country applications and out-country applications are still in place. People are entitled to bring their family members or to make applications, quite rightly so, for them to join them in the UK. And then the difficulty is that some relationships, I have already pointed out, have been formed. For example, if you're an EU citizen, and some people were not aware, sometimes some people go and contract marriage in Ghana, Nigeria. They will contact us that they want us to make application for their spouses under the EU settlement scheme, when in fact those relationships have either been formed or the marriage has been contracted after December 2020, then those ones becomes applications that cannot be made under the settlement scheme because they are out of the scheme's deadline, both the transitional period and then the deadline. The relationship have been formed after December 2020. But let's look at those who are here. I'll enjoy dwelling on those people who are here. And you remember we dealt with non-biological parents last week.
Last week, yeah.
I want to just elaborate the EU aspect in terms of some forms of relationship. So if you are a father of an EU citizen, and remember that I personally have a client who is a third country national. He has a child who is an EU national because the mother is from France. So under those circumstances, if that father wants to rely on the child who has pre-settled status, I've already explained for those of you who watched us last week that even non-biological parents can make those applications. Now, so if that father should make application as a child of EU citizen, so as a parent of EU child who has pre-settled status, then because that application falls under the appendix FM, they are equally entitled to a fee waiver, just like any other person. Now, for those who are in a relationship with EU EU citizens, in this case, maybe they could not form the marriage or they could not contract the marriage before December 2020, but they are living together. And those, let's say the mother or that partner might have a younger EU child who have pre-settled status. So by the fact that they have formed that relationship, they have become partners. Again, they can also make that application under the appendix FM. And because it forms under Family Law Article 8, they are also entitled to fee waiver. So it is not just application under the EU settlement scheme that is free of charge. People who are also making applications because they don't satisfy the settlement scheme requirements may also be entitled to fee waiver. So it's more or less free of charge as well.
All right, thank you very much, lawyer. I know you've helped a lot of people, to make application, obviously, that the fee will be waived, especially the NHS one as well. So thank you very much for the good job that you're doing for the community. Viewers, if you now watching us, I've been here in the studio with lawyer Thomas Beyebenwo from City Law Solicitors. Tonight, it's been very interesting. We've been talking about EU settlement scheme, the updates, and then obviously late applications. And lawyer has taken his time to go through all these questions. We're going to go for a quick commercial break, but before then, let me acknowledge viewers that are still watching us, because you guys mean a lot to us, and of course, I must acknowledge all of you. So, Cornelia is saying, great updates. Thanks City Law Solicitors for always updating viewers and the community we're building. God bless you, lawyer. Lawyer Thomas, yeah, that's right. And then, wow, very interesting, as said MC Chaka. Prince Atakra Nyamiche Tuswe. Hey, Prince, the greatest footballer in Asante Mampong. Prince is watching. Thank you very much, Prince. And we love we love the signs that you're giving. That obviously everything is going on well. Thank you very much. Yeah, Kofi Castor, Lancaster Chief, says, kudos, guys. Of course, Samuel Afari Afari is watching us. Nana Frema is here. Nana Frema, I acknowledge you, Nana. Thank you very much for watching, and I hope you're sharing for others to benefit from as well. Obibini Techi, just joining. Obibini, thank you very much for coming in. You are not too late anyway. Lawyer will give a summary, so you're not going to miss anything. Please make sure you stay for the update. Daniel Amanfo Kwabna, or D4 Daniel, my number one prophet. Daniel says, wow, what a fantastic and powerful program. I really like it. God bless you, Apostle Chaka and lawyer. In Jesus' name. Oh my God, I'm the apostle. Thank you very much. Thank you, Daniel. I take it.
Apostle Chaka.
Apostle Chaka, that's right. Cornelia Fripoma Jima. Always remember to join in every Tuesday and Thursday. It's very insightful, very informative, educative, all the big words. This program has come to stay. Thank you very much, Cornelia. Fred Asari. Fred Asari, Edmond Kwao is watching. Okay, thank you very much, viewers. So we're going to go for a quick commercial break. It's not going to be long, so please make sure you don't go away. Lawyer has done really well. He needs to drink some water. When we come back, I'll give Lawyer the opportunity to go through what he has already spoken about. And then, of course, I'll open the phone lines for viewers to ask various questions. Any question of your choice, the phone lines will be open. So please don't go away. MC Chaka and Lawyer will be back in a bit. Please stay tuned. Don't go away. Welcome back, viewers. So we've been talking about EU settlement updates and then late applications, and I've been here with Lawyer Thomas Beyebenwo from City Law Solicitors. Lawyer has been incredible. He's given us all the updates that we need. Tonight we've spoken about the EU settlement scheme, whether it's still open for applicants, the categories, people that are eligible for that, whether application or applicants need to give reasons for late applications, a lot more that we've covered tonight. The phone lines are open now, viewers, so please make sure you call the studio number, which is 079 3293 4518. I repeat, it's 079 3293 4518. And the other one is 074 40 33 8623. I repeat, 074 40 33 8623. The number is right at the bottom of the screen. So please call the studio line, and then of course pose any question of your choice. It could be related to this topic or anything that we've covered in the past, or any aspect or any area that City Law covers. Obviously, Lawyer is here and he will be able to answer your questions. Let me sell City Law a bit. City Law Solicitors, they are legal firm solicitors based in London. Address is Unit 113 Barking Enterprise Centre, number 50 Cambridge Road, Barking, Excess, IG 11 8FG. If for some reasons you want to contact them, either for directions or to go and see any of the workers there, you can call this number 0203 355 0782. The number once again is 0203 355 0782. Their specialties are in areas of immigration law, employment law, family law, personal injuries and clinical negligence, commercial dispute and civil litigations, housing law, consumer law, media and entertainment law. So if you're looking for someone to help you with any of these legal areas, please don't look anywhere else, but then please contact them. If you call the office and Thomas himself is not there, his learned colleagues will be there to support you. It's been very educative tonight. So I'm still waiting for viewers and listeners to call. And of course, Senior BM, I know you're listening to the radio. You've just prompted me. Thank you very much, Senior. And someone for you is listening. Senior Big Stone, listening all the way from Amsterdam and Big Stone. Wow. Thank you very much for making this program interesting. And yeah, Lawyer. So whilst we're waiting for people to call, what I'm going to do is I'm going to get you to summarize what we've discussed tonight. I know you're tired, but then please do us the honor and summarize, go through everything that you've said in relation to the settlement scheme update and then the late applications, please.
Well, I'll try and round up, because there's a lot that we have discussed tonight. So I'm just going to try as much as possible to summarize it. Now, we started the discussion by setting out the fact that UK went into transitional, when we left the EU, the transitional date was set from January to December 2020. That was a transitional period for people to make applications. This deadline was extended to June 2021. And within that period, a lot of things have happened. But most importantly, dependent relatives, which is extended family members, there is very good update for them, and that is the crux of this discussion tonight, even though I've looked at other areas that I'm also going to summarize. Now, Article 10, subsection 3 of UK EU withdrawal agreement sets out that family members, including extended family members, should be entitled to family permit, especially those who are applying from abroad. Now, so when UK left the European Union, these family members who made application before December 2020 and were meant to be extended family were meant to be granted family permits to join their family members in the UK. Some of those applications were refused, and therefore by June 2021, the excuse for not giving visa to these people were one, because the EU family permit, which is different from the EU settlement scheme family permit, was no longer valid for travel, so they were not going to issue to them. So people fought their cases, their appeals were allowed in the tribunal, but they were denied of the right to travel or to be issued visa to join their family members. There were those who also made those applications, and those applications were not decided until perhaps June 2021. Again, there was an excuse that even if those visas were granted, they were no longer valid to travel with. So they were also not issued those visas, including those who made application before December 2020, which was still pending. Now the good news is that Home Office, following numerous complaints from lawyers and civil societies, they have now given concession that those people are now eligible to be granted those visas. So if you have a family member in this category who is a extended family member who made application before December 2020 and it was either confirmed that he was entitled to visa but was not going to be issued, or appeal was allowed but visa was not going to be issued, inform them that they can now contact the visa centers to get their visas, because Home Office have set out that concession that they are now eligible to get those visas. So it's a good news for those people in those categories. I've also right,
lawyer. Thank you very much. I know you were going to continue, but then there's one thing that I need to emphasize on. I've got a question that I need to ask you quickly. You know, when you were talking about people going for the interview alone, back in the days, people were a bit scared. They were very worried to go, but then obviously because they've got an update from Home Office, they still have to be part of it. They both have to go. So couple entered the interview room, and some of us are not used to these people. Like when you see immigration officers, you even running away. Left alone seeing somebody who is obviously going to interview you for about an hour or whatever. And the man was panicking, but then the lady was very comfortable. Men, sometimes we do panic. We are the men, but we panic under certain pressures, So the lady was very comfortable, and then they asked them a couple of questions, but then it was not going to go well. So the man said, I want to use the toilet, and that was it. The man really escaped. The man left the lady and disappeared, and they were very upset. I mean, especially the partner, thinking that we've come for an interview and you've left me. And it's not this marriage is not marriage of convenience or whatever. We are legally married, you know. So tonight, this topic that you've brought, that obviously one person can enter or go for the interview, or just the applicant can go for the interview without going to the spouse, has touched somebody's heart, and he's giving this testimony that there was a time that he had to run away, and this is a direct testimony from this person. So thank you very much for giving that update, you know, I mean, for our viewers. So it's not mandatory, it's not compulsory for both of you to be in the interview room. And thank you very much, George, for sharing this update. Thank you very much. Okay, lawyer, so please continue. But then whilst lawyer is talking, the phone lines are still open. You can send your questions either by text message, or you can drop it to my personal inbox. I'll read it for you. So please make sure you obviously say something or come up with something, because there are so many immigration questions, legal questions. I get people calling me all the time. Oh, Chaka, what is this? Please, you've got lawyer here. If you call me next time, I'll refer you to him. So please make sure you ask any question that you intend to obviously pose to lawyer. He's right here, and this is an opportunity. We've got about 5 minutes to go. So please, lawyer, wrap up your last bit under 2 minutes, and then obviously we'll sign up. But phone lines are still open, viewers. Thank you.
Thank you. As I've said, it's not easy. Applications are being refused quite rapidly these days, because my reasonable suspicion is that they want to close the floodgate, which means that to discourage people from making so many applications, even after the deadline. So, but it doesn't mean people can't make applications. People who have formed relationship before this maturity are still eligible to make applications, which is called late applications. They only have to give reason why they couldn't do it before June 2021, and those reasons could be because they were unaware, or they were illiterate, they couldn't use the computer properly and all that. So those people who have legitimately formed relationship within that transition period or before the transition period, which is December 2020, they are eligible to make those applications. Now, why applications are being refused? Mainly, as I've said, they want people to show that they were residing in the UK before December 2020. So even though we are in 2021, most applications that are submitted, they want people to show something that will prove that they were here before December 2020. And as I've said, there are a list of numerous documents that people can rely on. It could be an invoice from a shop, it could be phone bill, it could be TV license, it could be bank statement. In fact, it could even be a college letter from the college. I mean, numerous documents. People don't have to, especially even EU, so that they don't have to show that they are exercising treaty right, because that is not a requirement anymore. If you look at the appendix EU rule 14, EU 14, it sets out two conditions: the relationship and residence, for especially those who are relying on EU nationals to make those applications. I've also set out that yes, I am not going to sit here and say it is easy. There are a lot of people being invited for an interview. I've been in this business for a while. I remember about 5 years ago, my clients, genuinely married, living together with a stepson, they went for the interview. They didn't do well at all, because the woman kept some of the information from the man, and they asked very private questions. So it's not that people go there and they don't do well, it's because their relationship is that of convenience. It's just because in a relationship, maybe I may come into a relationship, I might not give all the facts about myself, and therefore if caseworker has a question which is, and I give answer is different from the other party, it doesn't mean that their relationship is not genuine. But of course, that is a proof for Home Office to legitimately refuse application. So if people are invited and they know that they have these shortcomings, they can volunteer to go the interview alone. And I've said that the interview, it is not grounds for refusal, which means that if one fails to attend an interview or fail to honor invitation on 2 occasions. That in itself is set out, I think, page 216 of the guidance. That is not grounds for refusal. So people should be mindful of that. But as I said, it doesn't mean that caseworkers may say no refuse. Caseworkers will refuse, but people are entitled to fight those cases in the tribunal.
Okay, thank you very much. And then one thing that I would like to add to what lawyer said, sometimes some people might struggle with the English language, and of course they still need to be interviewed. So my advice on lawyer, I think, in addition to what that they should,
normally they provide
exactly they should people shouldn't hesitate to request for an interpreter, because that will give you the right to obviously express yourself in a language that you are comfortable with.
Yes.
So it is very advisable that if you're invited for the interview, as lawyer said, you might go alone. It's not mandatory or whatever for you to go with your partner. And then also, if you think that you struggle with the English, obviously you can request for an interpreter, and then you flow in your local tree or whatever language that you are comfortable with. So that is it. Lawyers, let me acknowledge a few people that are watching us now. Irabna is watching all the way from Germany. Irabna, thank you very much for watching us. Irabna, Safo Kantanka, God bless you. Thank you very much. God bless you too, Safo. Perpetua Kunedu, thank you. City Law Solicitors. Thank you all for joining us. Obviously, it's been amazing. It's been very educative. And thank you, lawyer, for being there to obviously give all these updates. So, viewers, I've still got 1 minute for the phone lines. Phone lines still open 1 minute. So, if you don't hear your voice, please make sure when they call me, I will refer you to lawyer's office. And of course, there will be charges. It's not going to be free when you go and see him in the office. So this is an opportunity for you to call. But then in the absence of any call or any further questions, then I can vividly conclude that, lawyer, well done. You've done really well. You've answered all the questions to a satisfactory level. And viewers and listeners are very content with everything that you've given tonight. So thank you very much. So viewers, this is where we will draw the curtain. It's been very nice. It's been very incredible to have lawyer Thomas Beyebenwo with us in the studio. And of course, he's given us an update on the settlement and of course, applications that can be made under that. Thank you very much for being my guest. Obviously, you've made this program very entertaining and exciting. Until we meet again on Thursday, lawyer will be here with the tree version, and this program will be through City Media on online radio, and of course on Facebook and YouTube on Thursday with the same topic. And then next week Tuesday we'll come with another topic for the English version. So thank you very much. I hope it's been a pleasant program. I hope you really enjoyed it. I hope Thursday's one will also be great as well for the tree version, and you can ask any question that you want if you were unable to pose any question to lawyer. Good evening, and you have a pleasant night. Thank you.